And so I'd like to introduce Michelle Littlewood and Denise Wilson, who will be presenting from Core HR on the topic of 2017 new employment and labor laws. So with that, I turn it over to the two of you.
All right. Well, thank you very much. Thank you, Dean, and thank you to the Craig School of Business and the Institute for Family Business for having us here this afternoon. I'm going to tell you a little bit about us, just so you know who we are and why we at least think we have the qualifications to stand up here and talk to you about the new laws. Our little company, Core HR Team, is a local business, and we work with businesses within the San Joaquin Valley to kind of help them with HR issues, with navigating the new laws, with staying compliant, with really figuring out how to get the most out of their employees and do so in a conservative and risk-averse way. And we do work with quite a few family businesses, and it's become a really great part of our business, and obviously really interesting to get to meet the different generations and learn more about the businesses. So we're really happy to be here tonight. There's a little information on us in a flyer if you want to pick that up. As it says here on the slide, we do provide a lot of different services for companies, and it really just depends on what that particular company needs. Quickly, our backgrounds. As Dean said, my name is Michelle Littlewood. I have been a lawyer since 1999, always doing employment law and always on the side of the employer. I litigated cases in the courtroom for 16, 17 years, and it was a miserable existence, both for me and for the client, right? Because if you make it to the courtroom, you've already lost, right? Even if you technically win, it's a huge expense, etc. So I decided to leave that and start consulting so I could help the employer avoid the problems that led to litigation. So that's really my motivation for leaving the courtroom. And my partner, Denise Wilson, she has the practical experience in our company. She's been in HR for 20-some years, worked for a lot of our local businesses, Pelco, Anlin, just to name a few. So together we bring the legal and the practical to our clients in hopes of helping them, again, with any HR employment related issues they may be having. So that's quickly who we are. We will jump right into our topic today. The goal is we want you to feel like you're prepared for the changes that are coming, so that you know what, if anything, you have to do to change in your business to comply with those laws. And we'll talk about best practices. What is the best way to comply with the law and still focus on your core business and growing your family business? We're going to have to take a little step back into 2016. Probably most of us were glad to see that year over, but we need to reflect a little bit because there were some changes that happened mid-year. So we want to make sure that everyone is aware of those. For whatever reason, sometimes the legislature decides right in the middle of the year to make a change. So we want to make sure everyone understands those. After we do a quick review, we will talk about those changes that are in effect. Some as of January 1, 2017. Some are going to take effect a little bit later in the year. So we'll make sure that you know what has changed and again what you have to do. We're going to talk about some local regulatory agency trends that we've seen in the latter part of 2016, and we have no reason to think they're not going to continue those trends into 2017. Talk about those. There's a few cases I want to mention, just so, again, you understand kind of what the employment environment is looking like for 2017. And then I have here questions and answers at the end, but please ask questions as you have them. Makes it so much more interesting for you and for us if we interact and we can learn from each other. So if you have a question, just raise your hand so they can get the mic to you, or shout out, and we'll make sure that you can be heard. Because again, it just makes the whole presentation more interesting if we make it interactive. Okay? All right. quick review of 2016, and these were really the happiest pictures I could find of the year. So there you go. There was, in April of 2016, there was quite a few changes made to the Fair Employment and Housing Act. So this is a state law, a piece of legislation in California that applies to employers with 5 or more employees. Does everyone have more than 5? Anyone under 5? Okay. So the FEHA applies to everyone in the room. And the basis of the FEHA is an anti-discrimination statute, right? So you can't discriminate, you can't harass, you can't retaliate. What changed in April of this past year was this idea of creating an affirmative duty of employers to take corrective action to prevent sexual harassment in the workplace. And what does it mean, an affirmative duty? That means basically you have a legal obligation to make some sort of effort to prevent harassment in the workplace. What is the some sort of effort? Well, it could be training, for example. It could be having a culture at your company where it's clear that if employees feel as if they are being harassed, that they can come talk to someone, whether it be an HR person, whether it be their supervisor. Any of those pieces would help to prove that you've taken affirmative duty. You need to make sure that you have a policy prohibiting harassment in the workplace. Everyone have an anti-harassment policy. You need to have that in place, and you need to make sure that it's communicated to your employees so they know that you have it and they know what it entails. And a written policy, another change from the 2016, is that it's mandatory for all employers, right? So there's always been this body of law that is applied to larger employers, 50 or more, in regards to sexual harassment. Now we're reaching into even the smaller employers and requiring some of these affirmative steps, and that you have a written policy. Yes?
How do you get that?
How do you get the written policy? Well, you can have either a lawyer or an HR consultant draft one for you. They're available if you're a member of like CEA or Cal Chamber, they could maybe help you with that. The trick is, and we're going to talk about this I think in the next slide, the trick is that policy has to be specific to your company. So it used to be that you could get away kind of with a boilerplate, we don't harass, we don't discriminate, done, way to go. No longer. So you have to have a policy that is very specific to your company. It has to talk about the reporting procedure at your company, meaning if I feel like I've been harassed or discriminated against, who do I go to at my company? Do I go to my lead? Do I go to my supervisor? Do we have an HR manager? So it has to be very specific. So you could certainly Google, sexual harassment policy and find God knows what, but the law has made it clear now that it has to be very specific to your company. Yes? It should be in most sexual harassment policies live inside your handbook. If that handbook, however, hasn't been updated since April 1st, 2016, you more likely than not need to amend your sexual harassment policy and then send it out as an addendum. So even the handbooks that we had done for our clients early in 2016, we had to send them out in an addendum. Because you're going to see now the law has said not only do you have to have a sexual harassment policy, not only does it have to be specific to your company, but there also has to be very specific things contained within that policy that typically ones written prior to April 2016 did not include. Okay, any other questions about that? So here's really this last piece, this number 4. Mentions some of those specific requirements, right? So it's got to say in your policy that you're guaranteeing a timely response. So I've made my complaint, I'm the employee, I need to say to you, we're going to get you a timely response. We're going to conduct an impartial and fair investigation, which could mean that you need to have a third party do the investigation, or someone certainly not involved in the complaint. It has to have a statement in your policy saying that if misconduct is found, immediate and corrective action will be taken. And then it's got to tell the employee that you're going to be documenting this whole investigation, and you're going to tell them what the progress is, how things are going. You don't give them any details, but all these 4 things need to be included in your policy. You also need to make sure that your reporting procedure, so you'll have your we don't discriminate, then you're going to have that specific what do we do if you feel like you've been harassed or discriminated against. If it's a well-written policy, it will have always said that you can go to someone besides the person you think is doing the harassing. But now, again, it's a legal requirement that it say something to that effect. So it has to give that employee lots of different avenues that they can use to make that complaint. So, for example, it could say you can go to your immediate supervisor. If you feel like you're not comfortable going to your immediate supervisor, you can go to the department manager. If you don't feel like you're comfortable with the department manager, you can go to the owner, or you can go to HR. It also has to say, I'm sorry about this, it does have to mention that if nothing else, you can go to the Department of Fair Employment and Housing. Right? So you have to make sure you have all those different possible routes laid out in your policy for your employees to understand. Okay? This last one, hopefully everyone's policies say that, but certainly when you get back to work tomorrow, double check. You have to have a statement saying that the employee will not be retaliated against for making a complaint. Okay? So you need to have all of this contained in your policy, right? Okay, does anybody have 50 or more employees? Nobody? Well, then I'm just going to go quickly through this next couple slides. So you're lucky, if you're under 50, you don't have to have mandatory sexual harassment training. Now, again, remember, now you have the duty to prove that you've taken, you have an affirmative duty to show that you've taken precautions against sexual harassment, and training is an excellent way to do it. For employers that are 50 or more, they actually have to, by law, do sexual harassment training. And the worst part, it has to be 2 hours, which is painful. But you guys don't have to do that. If you get near that 50 mark, make sure that you remember, if nothing else, that there is this requirement, and quite a bit actually changed in April in regards to AB 1825. But I don't want to waste your time, so we went past that. Okay. Another thing that happened mid-year 2016 is that the Equal Pay Act was amended. So it's long been in California that you cannot discriminate against an employee because of their gender in regards to pay, right? Nothing new there. But what was changed in April of 2016 is, again, it's spelled out in the law that the employer has a heightened burden of proof to prove that the reason I'm paying Bob more than I'm paying Susie is because of some other reason besides the fact that Bob is a man. Maybe he has a higher education, maybe he has more experience. Again, that's always been the rule, but now the legislature has specifically said, employers, you have a high burden of proof, right? If it's just he said, she said, or if all else equal, they look like they should be paying the same, then employer, you're going to be the one that is going to be found liable for discrimination based on gender. The other really important piece that changed in April in regards to the Equal Pay Act is this statement that employees have to be allowed to discuss their wages. Okay? Probably 10-ish years ago, we used to see in handbooks all the time a prohibition against discussing wages. That has been, most employers have taken that kind of language out of their handbooks, but they've still had a culture or some sort of kind of understanding where you're really not supposed to tell, don't tell Denise what you're making because you're making more, this sort of kind of culture. That no longer can be. We have to allow employees to discuss their wages. I think the reasoning behind that is, how can I know that Bob's making more money than me if I'm not allowed to ask Bob, right? How much are you making? We're both managers. What do you make? This is what I make. Or ask somebody else. So if we don't allow people to talk about their wages, then it's going to be really hard for an employee to even know if there's a possible equal pay violation. Yes?
Your bullet says, for purposes of ascertaining whether or not there may be a equal pay claim.
Correct.
So if two employees of equivalent stature of the same gender are discussing, this does not follow the purpose of ascertaining a potential claim.
Well, maybe they want to see what each other are making so that they can compare that with a male manager that's in the company. And again, this is just this statement pertaining to the Equal Pay Act, right? There is a whole other body of law, especially when you're talking about the NLRB, or the NLRA rather, which is the National Labor Relations Act, that says specifically you have to allow people to talk about the terms and conditions of employment. So even if technically, if we could prove that Mary and Cindy were talking about their wages and it had nothing to do with determining whether or not Bob was making more or less than them, there's going to be other problems with us prohibiting them talking about their wages. So the bottom line is, you want to make sure that at least you, as the owners and the managers, are not doing anything to prohibit or discourage people from talking about their wages. Now, that employee may say, I don't want to tell you what I make. And that's fine. You know, none of your business what I make it. That's all fine. But you, as the employer, or the manager, the owner, need to make sure that you're not doing anything to discourage that. Okay? Okay, so how does that affect your business? Well, again, you want to make sure when you're going through your handbook, you want to make sure that you pull out any language that's going to be interpreted as, requiring people to keep confidential any information about their wages, right? You're going to want to train managers and supervisors about this requirement so that those managers and supervisors aren't saying to their employees, you guys can't talk about wages. Right? So you need to let them know, hey, look, they can talk about it, can't discipline them for that, can't tell them to stop, right? Tell them to get back to work, that's fine. But you can't tell them they can't talk about the wages. And then the best thing to do is to really look at your workforce and see if, when you've got two people in the same position, it's a man and it's a woman, and we'll see, because in 2017 this is going to be expanded even into further into ethnic groups and so forth. So if you've got people in the same or similar position and they're not making the same wage, which happens all the time, just make sure you have some sort of legitimate reason for doing that. All right? And that legitimate reason can't be that the other person, is of a particular race or gender. It can't be that just because that person's always made more. You have to have some justification for the wage difference. And if you do, you're good to go. Okay? All right. The other big thing that happened in late 2016, I can't remember exactly when, OSHA came out with a statement about post-accident drug testing. Everyone know what OSHA is? Occupational Safety Health Administration. So a lot of people have been engaging in a practice where if there was an accident, they'd take you for a drug test, right? Post-accident drug testing, which, by the way, has always, or for a long time, not been okay in California. But now OSHA has expressly said you cannot have a blanket, there's an accident, we're going to take you for a drug test, okay? In California, you need to make sure you have reasonable suspicion to take an employee to a drug test, right? The accident in and of itself is not reasonable suspicion that they're under the influence. So you have to have, they got in an accident and they were slurring their speech. They got in an accident and they reeked of alcohol. They got in an accident and they had bloodshot watery eyes, we're talking funny, acting funny. You have to have some other component with it. That's really always been the law in California, although we have found that employers have not been following that. But now we've got a regulatory agency saying you can't have post-accident drug testing, absent a reasonable suspicion.
Is there any exemptions for certain
Yeah.
industries, like truck drivers that drive oil trucks?
Yeah, so the DOT folks that are going to fall under that because they're driving big rigs or whatever, they can do random drug testing. You're good to go. Test all you want. But for most industries and most businesses, there's not going to be an exception. Yes.
What if you have a hazardous occupation?
So there is a narrow exception for safety positions, but if you actually look into what that is, it's very narrowly defined. So it's not just that, oh, Bob operates heavy equipment or the machinery, then we can just randomly test him or we can test him post-accident.
High voltage electricity, that sort of.
Yeah, so I mean, it would really be, it could be that you have a category or a class of employees that based on their specific job, you would be able to find an exception to this, but it's very narrow. So you really need to talk to someone about that. Yeah.
Cal OSHA consultation would probably be able to help you too if you want. Not that
I'm
people
sorry.
like to bring Cal OSHA consultation. You can always call them and say, usually it's not anonymous. You don't usually want to say, hey, you're Cal OSHA, I'm here. But if you're trying to do the right thing and you want to ask them, they're a great resource for you.
They are. So,
If you're doing everything right, they're a great resource for you.
and they'll come out, Cal OSHA will, they'll look at your facility and they will kind of give you a fix-it ticket with, they say without any repercussions. Hopefully they're being truthful about that, but it is a great resource, especially on questions like that where it's going to be a tough one. Okay. Anybody else? Okay. We talked about this. Again, you're going to want to look in that. I keep going back to the handbook because I'm a big believer in a good handbook. Go back to your handbook. If it has language in there about post-accident drug testing, get that out, right? Then you'll want to make sure, though, that it has some language in there about if there's reasonable suspicion that you're under the influence, that you can be tested. You need to have a policy so that you can exercise this right as an employer. Okay, you need to notify them that they should have a lessened expectation of privacy if they come to work under the influence. And this is going to be particularly important because, as we'll see in 2017, right, marijuana is legal. So we're gonna want to make sure that you've got some good language in your handbook so it's clear that if someone's under the influence, you can take them for a drug test. I'm going to say now, because it seems like a good spot, what can you do if someone comes into work and they seem like they're under the influence? They trip or they're slurring their speech. Or they, yeah, we went to a client today who said, my employee came in with white powder under their nose. Well, yeah. And this person ran into his office and was like, I don't know what to do. What could you do? Could you take him to get drug tests? Sure, but what could you do right away? Just ask them, right? Employers are so scared because there's so many laws, which there are, but you do have a lot of rights still. I know it probably doesn't seem that way. Just ask them, hey, you got white powder under your nose. You snorting coke? No. Okay. Yeah, don't. I mean, what? Explain it to me then. Or you can say, if I come in and I'm slurred speech and I reek of pot or alcohol, look, you smell like alcohol. Are you drunk? You can ask them. And you will be surprised how many people, probably because they're shocked that you're just asking them. Well, okay, I just had a swig of, okay, great, bye, you're terminated. And now you don't even have to pay for the drug test. So don't be afraid to ask them, right? Okay, sorry, just had to get that in. Smoking at work is a new one, sort of. In California, you can't smoke within, a lot of buildings. Now, I don't know what brought this about, but there's a new law that's basically saying if you're a one man or a one woman shop, and so you're the owner, you still can't smoke inside your own building. So it's the wet rule?
Bar,
Yeah, there you go. It's just been,
bars, people would smoke in them.
oh,
Make the owner concerned.
oh, so that's what, okay, I was wondering, I was like picturing like an accountant just alone smoking in their office thinking, that is so weird.
There's
Okay.
a bar in Carmel that all the smokers went to.
Oh, okay.
It was an owner-only run bar,
There you go.
and so he smoked, so they could smoke.
There you go. Now I'm gonna change the slide to say the bartender rule. Okay, so if you smoke and you're all by yourself in your building, please don't anymore. There you go. Yeah, this is all I really have to say about it. Just don't. Okay, so now we're into 2017. Okay, everyone ready? The biggest thing is this is the start of this 2 different tiered minimum wage increase. So we talked about that we don't have anyone with 50 or more. Do we have anyone with 25 or more employees? So okay. So hopefully you know that what is it, the 10th or the 11th? Starting a couple weeks ago, the minimum wage went up to $10.50, which affects what else? Your salary basis people. So if you've got exempt employees and they need to make twice the minimum wage, now that minimum wage for you guys is $10.50. For smaller employers, the increase to minimum wage takes effect a little later. So we have this little chart for you. It's just going to be confusing because now we've got this kind of different tiered wage going on. But you'll see too, if you have your new 2017 labor law posters, which you all should have up in your conspicuous place, break room, whatnot, it'll have this similar kind of chart, right? Yeah.
I understand the relief that employers under 25 have with having one more year.
Uh-huh.
But has anybody looked at how that might be discriminating to me, the employee? Why is it taking me a year longer to get to the same rate as my friend who works for a company with 27 employees? That's strange.
Not that I know of. Don't tell the plaintiffs bar that. Now we're gonna. Yeah, I don't. Yeah.
It's not based on, it's based on.
Yeah, I guess
whether or not the employer
they
has
could go work for
funds
someone
to do
with.
it, I guess.
Is it based on the beginning of January? So
Oh.
January 1, because strangely I have a question where I have someone who went from 26
Yes.
employees to 24 employees in like our last week. What would they now, when someone was hired, now they're number 25, are they gonna get paid at $10.50 or you know what I mean?
So there's a lot of times when statutes are employee count driven, they'll have what we call a look back period, right? This does not. I will tell you, I would not counsel a client to decrease the wage, right? Oh, we were at 27 yesterday, I fired 2 people or 3 people, woohoo! Everyone's getting 10 now. You know, that's not gonna fly. Hi, Erin. Hi. So I definitely wouldn't do it that way. I would, as soon as I hit that mark, I'd bump everybody up.
The pay period where you pay everybody, yeah.
This is another thing we always tell our clients, don't be the guinea pig, right? Someone, I guarantee you, someone's gonna be like, oh, I'm at 24, I'm gonna reduce everyone's wage. Let them try it out and see what happens. And then, you know, so I would be very conservative with these counts.
What about going the other way? You grow from 20 to 28.
Yeah, then you raise the
And
minimum.
then immediately this.
Yeah, so that payroll where you had that many, because that's what they're gonna look at is your payroll and how many people were on that, how many paychecks did you print? And so as soon as you hit over that 25 mark, I would do it on that payroll.
Mhm.
And then you don't have to give them notice for an increase, you just have to make sure it's on the pay stub, so it's not like you need to give the employees notice to get the increase. But you would if you were decreasing.
How does this affect you? If you're in that mark that you're now at the 1050, obviously that's going to increase your labor costs. As I mentioned, it's going to increase your exempt employees to meet that salary basis test. That's also going to increase to the 43,680 unless this 47,476 comes back into play. Doubtful, but you need to make sure that you're meeting the California requirement at least as of right now.
Wasn't there some sort of judgment about that recently that suspended it?
The 47.
Yeah, that suspended this. Yes, it was supposed to take effect December 1st, and it did not. There's a stay, it's called, so just kind of status quo. But this, if you are in California and at that larger employer mark, or employee mark, you need to make sure that you bump them up to 43,680. The EEO1 reporting, which is not going to affect anyone in here, right? Because we don't have any 100 or over. So I'm going to zip through that. Okay. I-9s, that does affect everyone in here. So the I-9 form has been revised. The good news, and Denise even said this, and she rarely says something positive about a change in the law. Just kidding. Not really. It's easier to fill out. It's easier to complete. Okay, the drop dead date I think is January 21st. I have it on the next slide. To implement the new I-9 form, but it's easier. So if you haven't already been using it, please going forward, starting tomorrow if you hire someone, use the new I-9. And then as of January 21, you have to. And like I said, it's actually easier to do, and same as always, you have to complete it within the first 3 days of employment. Okay? Yeah.
There are onboarding processes now that are electronic, ask the employee to upload the required supporting documentation, yet previously, as I recall, it said the employer must actually see the supporting documentation. Is there any liberalization of the
I have not seen.
Not that I'm aware of. No, you still have to see it. Yeah.
And the electronic, even storage of I-9s is about this long. The requirements that you have to safeguard the information and where you keep it and all of that. So I don't know. I'll have to look that up and see.
Yeah, I haven't
if we
heard
can
anything.
do that electronically because that would be needed to be. No, we can't.
Did anyone else hear that that has changed? Yeah.
We work for a company that does electronic I-9 is part of an onboarding process. And
Oh,
the law
there you
has
go.
changed. And there are, as long as it's separated and protected in its own space, and it is, and as long as they have documentation that they have received the actuals in a copy that could actually be printed, you are now able to do your I-9s electronically.
The
actual
verification.
Verification, as long as there's documentation behind it that someone did it, it's on actual, could be printed, doesn't have to be face to face, but it is now, you can check it like, I know for sure.
Well, no, that's
We've been
great.
working
I
for
didn't
a
know that.
year on that legislation, not our company, but the federal has on the electronic side of it.
And then do you have those safeguards
Then
that you were
have to
talking
safeguard
about?
the documentation as well.
Yeah, because it's very specific,
Right.
but that makes sense if that's something that you guys do. Because I think our average employer is not going to have that sophisticated of a cybersecurity to do that. I guess I'm interested. I'll talk to you after. My concern with doing it electronically though. How does the employer fulfill their obligation of at least making sure that it doesn't look on its face completely fabricated? I mean, Denise tells me stories of when she was in HR, you could see the scissor cuts around. You don't have to be a trained, but some stuff is so obvious. So I'm just curious, I wonder how that's going to play out, because if it's electronic, well, I guess you might see the scissor marks, but maybe not the glue oozing out the side of the ID. So anyway, good to know. Thank you. All right. This is for the OSHA 300s, which isn't going to affect some of you at this point. But if you're 20 or more, then you're going to be required to electronically submit your 300A forms. So if you fall into that 20 to 249, which I think a lot of you do, then make sure that you understand this 300A form needs to be done electronically. And this change would include your reporting for your 2016 injuries. Okay? So,
those are certain industries, did we say? It's like the hazardous industries, I think that's what that's for, and then you have another year before you have to do it if you're just a regular industry.
Yeah, so there are certain agriculture, construction, ambulatory healthcare services that's going to kick in immediately, and then there's others that are exempt. So you're going to want to make sure that you know whether you fall in that electronic reporting requirement or not.
I don't think so. That's the one that you send in, and then you still have to post the injuries of each
Yes.
case.
Yeah,
Yes,
yeah.
yes.
Okay. How does that affect you? Just be prepared if you fall under those categories that need to do it. Make sure you've got someone who can help you with that. All right. So we talked about what the Equal Pay Act and how that had been amended in 2016. In 2017, the Fair Pay Act was amended further, and we are now saying an employee's prior salary cannot by itself justify any disparity in compensation, employees' race, ethnicity, or gender. And really what this means is people use those applications that ask for like prior salary, right? The idea being that people of a certain ethnic group perhaps have always been underpaid, right? So if you're using that prior salary as a justification for, well, I'm going to pay white Joe more than black Joe because black Joe is making less in the past, so he's probably going to take this, that's not okay anymore. If you were doing that in the past, you can't justify a compensation difference based simply upon someone's prior salary. So if you use those applications, or if that's something you typically ask people during the interview process, then just be aware of that. You know, there could be 10 other reasons why you're going to pay one person more than the other, but it can't be based solely on prior pay history. Okay? All right, how does that affect your business? Again, you're going to want to make sure, because everyone can discuss wages. This is another place, another statute where we're finding that statement. So again, go through your handbook, strip any of that, train your managers, and then again, do that pay structure review again. Look at, are people in the same position being paid different? Fine. Why? What is your justification for that? Right? So effective March 1st, I can't help but smiling because I'm standing in front of people talking about restrooms, and it's just so bizarre to me. But as of March the 1st, this law comes into effect, and it's the single-user restrooms. Okay. When we did this talk before, we got a lot of questions about this. So I'm going to try to explain it, and hopefully I'm not going to be confusing or laugh too much. But a single-user toilet facility has to be available to both genders. So what I always think of, imagine that gas station bathroom, right? So you go into the gas station, there's a man's and a female male restroom, but there's only one stall in each of those, okay? Locks the door, one potty. Beginning March the 1st, you no longer can have male and female. It just needs to be all of the above. Everybody and anybody can go into either one, okay?
You have to take off the sign.
Take
You
off
have
the
that signage that
You have-
reflects, yes.
Yes.
That makes the very good lesson.
Okay. If you have a restroom that has 2 different stalls in it, do we have to make it no lock? Yeah, no lock on the front door. Do we have to make it a single user? No. Okay. Right.
It's not single user.
Right.
Yes.
You're using the term stall. So if there are not stalls separating, say, 2 or more commodes, as is often the case in
Mhm.
men's restrooms with adjoining urinals.
The key is going to be that lock on the door, really. Okay? So if I can walk into the bathroom, I lock the door. No one else can get in. Not locking the door of my little stall, but I'm talking locking the door from the hallway. Then that's what we're looking at, right? If multiple user bathrooms usually don't have that lock, right? They have the individual stalls locked. Those you don't have to change to single user. If I've got a lock on the door, even if I have a stall and a urinal, but I can lock that door, then it needs to be single user.
If you have two stalls.
See, this generates so many questions.
I'm just saying, at my office,
Yeah, I know.
for the complex,
Okay.
not inside my office, is the men's room has two stalls, and the ladies' room has two stalls.
Okay.
Those can remain,
Yeah, because they don't walk in and lock the door, right? So nobody else can go in after you.
They probably do lock for security.
they're locked.
But
for
not
security.
for, yeah, but not for use, not for,
Because if someone else
You
had a
have to
key,
have a key to get in.
right?
oh, to the,
But somebody else could have the
Ah.
key. It's not like you're
Right.
locking it for no one else to use it.
No, I don't
Yeah.
lock it, it's
Yeah.
perfectly
Just
locked.
used for,
Yeah.
yeah.
Then that they're not going to switch to single user.
Yeah, okay, that's up to
Any more toilet questions?
So I was in a business today that had two single
Okay.
doors.
Okay.
One had the little lady skirt, and
Okay.
the other one had the lady skirt and the man. So I looked at that and I thought, I wonder if they took the men's room and turned it into the dual use, but left the ladies' room by itself. Is that acceptable?
Not if not if the ladies is a single use. But maybe they had, the women's is stalls,
Yeah.
and then the other one is a single use, so they turned it.
Yeah.
Yay for us.
Yeah. Okay, thanks.
Maybe our line would be so wonderful. Right, exactly.
And you looked up the signage requirements,
Yeah.
right?
Uh-huh.
What is the sign?
Well,
It's like half a skirt and
no,
one
you can
pants
throw
bit.
it. Just put restroom.
Okay.
There you go.
It just has to be identified
Yeah,
as.
you don't have to have all kinds of different
Yeah.
things, you know.
Or French.
Okay.
Moving on.
Anyway, please move on from the potty. Okay. Another change in California in 2017 deals with our ability to, as employers, to ask for and consider criminal history. And the specific change in the law is listed on the slide, but you can no longer ask, if you had been, ask applicants to disclose, nor can you use as a factor in determining any condition of employment information concerning or related to an arrest, detention, process, diversion, supervision, adjudication, or court disposition that occurred while the person was subject to the process and jurisdiction of juvenile court law. So all that to say is basically you can't use, which we probably would have told you not to use anyway, you can't use juvenile court records and history to make any sort of employment decision for an employee. Okay?
That's juvenile.
There's lots of laws regarding what you can do with non-juvenile.
Because what if you're a business that has confidential information?
Right. This is just the change, right? So there's always been prohibitions and guidelines about using criminal history for any term and condition of employment, period. But this is specifically calling out and saying under any reason, because there are certain reasons that you can use criminal history to make employment decisions, right? This is saying basically you cannot use juvenile court records. Doesn't matter. So
So the most important thing in that bullet point is the last three words.
yeah, really.
Which normally don't show up anyway.
Yeah, usually it doesn't.
Have you been convicted of a felony, is that
I
fine?
feel like it's like writing laws.
Or do I need to have this
Well,
parentheses?
you know what? That's a good question. So Aaron's asking. So a lot of people probably have on their applications, the question, "Have you been convicted of a felony?"
And then if they say yes, we ask what?
So we may need to work on that.
To parentheses, put something else.
Luckily, you have a reliable HR
HR
company helping you. So we will. Yeah, I think it would be right. No.
I don't like that. I mean.
Well, you don't like having it on at all,
Right.
which is
You can still run background checks and get the information you need, but asking the question on an application anymore is just, it's really tricky. How
But
you have
it's-
to have it worded. That would be
You
an
can ask
after application.
Because
all
a lot
the
of people that
disclaimers
apply
there
for us
wanna-
have been, and
Yeah.
if it's theft or drugs, we do have to consider that, because that's a problem in our industry, so it's.
And
worth
you're-
it.
Do you run background?
We do not run.
So you're counting on people to tell you the truth.
And they
But
do
they sign
sometimes.
it saying they're telling the
Yes,
truth.
they do.
Yeah.
So, but that's a good question though. If you have something like that on your application, it would probably behoove you to qualify if you're going to have
You have
one.
to with marijuana.
Yeah, it'll
That's
say.
what I mean, the disclaimer's gonna be longer than
Yeah.
your employment history.
But good point. Okay. How does that affect your business? Again, if you use criminal history or have in the past, or you have in your application a question about it, it may affect how you ask that question, and it may affect what information you can and cannot use in regards to criminal background. Right. Okay, so there's an additional notice requirement that is become effective in will be effective rather in July of 2017. It's the Employment Protections for Victims of Domestic Violence, Sexual Assault, or Stalking. Basically, what this means is you're going to have to add to your list, which this is everything that needs to be included in that new hire packet, right? You're going to have to add to it this additional pamphlet. That isn't out yet, at least last I checked it wasn't, but it should be out so that you can include it beginning July the 1st, 2017. Okay? So nothing really, no monumental change, but there will be yet another pamphlet that you need to add to your list. Anybody have arbitration agreements? Good. Don't.
I bet they
Do you?
do. Somebody does.
Somebody does. You don't want to fess up to it, that's fine. If you have an arbitration agreement, which question whether it's going to be enforceable or not, but there has been a change to the law which basically says you can't have a choice of law provision. So sneaky employers used to have an arbitration agreement and say, yeah, and you have to litigate it in Texas, right? Because in Texas, the employer is going to win probably. Can't do that anymore. If it's the employees in California, you have to litigate it in California. But if you don't have an agreement, that's not going to affect you. All right. So my other favorite new law, in addition to the toilet law, is the marijuana. Okay. So it is now okay to possess up to an ounce of marijuana, which means it's okay to smoke marijuana, right? Legal, I should say. Your mom's in death, I don't want you doing it. But I'm saying it's legal now. So that confuses and complicates life for an employer, does it not? I will start this whole conversation with saying there hasn't really been any guidance, certainly no case law yet, we're only January, 11th. But it's unknown exactly how this is all gonna play out. Denise is hoping, as am I, that we get some guidance on what level is okay, what level is not. Because as you know, marijuana stays in your system for a long time, right? It's not like having someone take a breathalyzer test and determining whether they're intoxicated from alcohol or not, right? I could have smoked, and I didn't, this is hypothetical. I could have smoked a joint 3 days ago, and you send me to get a drug test today, and I still pop positive for marijuana. Doesn't mean I'm currently under the influence, right? But it's still in my system. So it's going to be really difficult if you do post-offer pre-employment drug screening, and an applicant comes back and they had marijuana in their system. You can no longer disqualify them because it's not an illegal drug. So it's going to be difficult. The one thing that I think is not going to be as difficult as some employers are worried about is the idea of being under the influence at work. So you need to kind of think of it as how we treat alcohol, right? Alcohol is a legal drug, right? Employees can drink. But can they drink at work? No. Can they be drunk at work? No. So it's the same kind of idea with the marijuana. So you can still prohibit it being on your premises. You can prohibit people smoking while at work. You can prohibit people from being under the influence of marijuana while working. And you're going to look for the same kind of signs, et cetera, that you did for alcohol. Okay? Yes?
So, let me go and rewind a little bit on, cannot disqualify them because it's not legal.
Well,
Or it is legal.
It's unclear whether you could, I think.
Okay. Am I correct in understanding that the proposition as it was passed had no verbiage to that effect?
It didn't have like a limit, right? So and it talked about some of the, not the actual proposition itself, but some of the pros and cons, talked about the struggles of an employer. And it talked about what to do on the job. But it didn't talk about, at least I don't think it talked about, the pre-employment drug screening. Because it's going to be as if you popped positive for alcohol. You're not, for that pre-employment drug screening. Probably not going to disqualify them for that. If we had some guidance on levels, I think that would be helpful. I don't know. What are you going to do when you have reasonable suspicion and you send them to get drug screened? If it's in their system at all, if alcohol's in their system at all, if meth is in their system at all, then it's easy breezy, right? They were at work, they were drunk. But if the marijuana's in their system and they say to me, well, I smoked 4 days ago or 3 days ago, it's just going to be, I think it's going to be very difficult. So I would just caution people, if you're going to make a decision based on the finding that there's pot in someone's system, just be careful. Someone, again, is going to be the guinea pig. Someone is going to write the law by way of probably getting sued or not getting sued. But so let's see what happens. But this is so new. It makes me uncomfortable, those pieces of it. That what do you do when the pre-employment drug screen comes back or the reasonable suspicion drug screen comes back and they've got marijuana in their system?
The reasonable suspicion would be easier because you have
Something
other
else.
behaviors, the reason why you sent it in the first place. So you would have that coupled with the positive. I would feel more comfortable
Yeah.
making a decision.
I
based on
agree.
that. But the pre-employment would be, because you don't have the opportunity to see them. That's why you're allowed to do pre-employment. Pre-employment's almost like a random.
Yeah.
But you can do it because you haven't had that opportunity to witness their behavior. Like if you have temps, for example, if you have temporary workers and then you drug test them when they come on board as a new employee, that's a random drug test. So you shouldn't do that. If you have an opportunity at all to see their behavior, that's what they're looking for.
Are you aware of any language in federal labor laws and regulations that refer to the states in particular in this instance? Because we have the basic conflict of
Right.
federal law saying,
Right.
what you say California, it's not legal.
Right.
Um,
And there's nothing particular to this. I mean, that struggle continues and will continue. That
I know there are other
So-
instances where
Right.
if the state law, labor law is more
Right.
favorable, more restrictive.
So again, someone's going to challenge it. I have no doubt that some employer is going to take some adverse employment action, or they're going to not hire a candidate because they pop positive for pot, and they're going to say that it's illegal under the federal law. Marijuana is. I have no doubt that's going to happen, but let's let them fight that out. And that's my conservative opinion as far as I don't want you taking the risk, but someone will make that argument. I have no doubt.
Your prior slide said that it's okay to possess up to an ounce. But this is not to have the possession of work.
You can just like you can.
Prohibit alcohol.
You're not going to let me bring my vodka on. This isn't vodka, by the way. I should have said rum. You're not going to let me bring alcohol on the premises. It's the same idea. Yeah. So don't those kind of things. Think how you treat alcohol. Can't bring it on the premises. Okay. Yeah, that you can possess an ounce is not at work.
Yeah.
Okay. Anyone in ag? You're just killing my slides. You're in ag?
Yeah.
How big? How many employees? Small? Okay.
Two.
All right. So, as you probably know, the minimum wage and the overtime rules are changing a lot for ag. It's all in the slide set. So look at that. It's based on size, kind of like the minimum wage. So you're going to be phased in much slower than the larger agriculture establishments. So just be aware of it and keep your eye on it. Okay. Then there's a few cases that have come out in the last 12-ish months that we want to talk about, just so everyone kind of knows what's happening in the courts and where we can see things going as we go into 2017. There was a big case that was decided in April of 2016, and it had to do with having to make a reasonable accommodation for an employee who was taking care of a disabled person. So it's long been, obviously, that if you have a disabled employee, you have to reasonably accommodate them. It has also long been that if you cannot discriminate against someone because they're associated with someone who is disabled. This takes it one step further and says now you have a duty to accommodate the person who themselves not disabled, but they're taking care of someone who is disabled. Now this is a Second District Court of Appeal case, so right now it's only applying to Southern California. Likely the employer is going to appeal this. It's unknown, but just know that this is kind of the trend of the court. In this particular case, what happened was you had a guy who had to leave early every day so that he could help his son with his dialysis machine. Supervisor A, totally cool with it, let the guy leave every day, no problem, right? Supervisor A gets promoted, Supervisor B comes in and says, no, you don't get to leave early to take care of your son. We're not going to accommodate you in that way. And the court said, no, you have a duty to reasonably accommodate an employee who is associated with or taking care of someone that's disabled. So this doesn't, don't anybody panic, it doesn't currently apply to us here, but it does apply to the Second District of California and could be trending our way, okay? So basically what this means, at the end of the day, you have to go through the interactive process with that employee just as you would if they themselves were disabled. Yeah?
Question on how close does the person have to be to the person they're actually going to be taking care of? And second of all, do they need any sort of medical certification in this?
So the court here, it was a big deal that it was the guy's son, right? So they didn't draw a line, like it was your Aunt Susie from they didn't draw that line, but I will say a good chunk of the opinion dealt with the fact that this was his son and that he had previously been able to do it, right? So clearly you're exactly, the employer can't say it's an undue hardship for us to do it because you just, for the last 3 years, let him do it. So, So those factors played heavily in this court's decision.
So as part of the reasonable, or part of the interactive process, you could ask for something from a doctor, which is what
Yes.
you're asking.
Yes.
Saying how often does it need to happen, does it need to be from 3 to 4? I think we can ask that but it needs to be as part of the interactive process and documented and all of that.
Right, just like if it was the employee themselves, that you could ask questions about, what their limitations were, what they could and could not do. Same here, I would think. Any other questions on that? So, the reason for this slide is twofold. Interesting cases that came out at the end of 2016. And also to make the point that people being employers, still make really dumb decisions that are very costly. This first one is my favorite. There's a bartender at a bar. She goes to her supervisor and she's like, look, I'm pregnant. I'm having some complications. As I get closer to my due date, my doctor said I need some time off. And she was fired. Who fires the pregnant lady? Nobody. I don't care if she's the worst employee you've ever had. Do not fire the pregnant lady, okay? So, don't fire the pregnant lady. So, that was November 2016. So, it clearly still happens. The other case I liked because dealt with industries that are historically male, which is kind of near and dear to my heart as a lawyer, and the way that this particular female was treated, right? So they had this kind of boys club atmosphere and she was excluded from that. She didn't get to participate in some of the chatting amongst the employees, and so she sued and was successful for gender discrimination. Okay, and that again was also in November of 2016. So still alive and well. Okay, a really recent case, mid-December maybe, I think, has to do with it was California Supreme Court, so it applies to all of California, and it had to do with on-call rest periods. So, I don't know if this applies to anyone, but as we know, the 2 10s, your rest periods, they're paid for, but they're supposed to be free of any duty, right? You're supposed to actually get to rest during those 2 10s, okay? This security company basically said to their employees, yeah, you can take your rest periods, but we want to keep your walkie-talkie on and still, patrol and make sure no one's doing anything bad. So really it wasn't a period of rest. And so the court said you can't have an on-duty rest period, just like you, in most 99.9% of the time, cannot have an on-duty meal period. Okay? So, but what the court said, the bright side, is the court said, if, like, let's say I give you your 10, and then a big group of customers comes in, I can say to you, look, you're going to have to, sorry, I need you to work. That's fine, but then you get your 10 after, uninterrupted. So the court didn't say, there was some bright side to the opinion. You can certainly say to your employee, they say, I want my 10, great, we're really busy, can you take it in 20 minutes? You can still say all of that. It's just that you can't, they need to actually have a period of rest. So if you're requiring them to still answer the phones or check their walkie-talkie or whatever, that's not going to be okay. Yes?
So what's the general rule for employees that want to waive their 10-minute period and always waive the 10 minutes? It's their choice. They want to waive it.
I thought you just had to allow.
Culture.
Yeah, you have culture, you have policies in your handbook, you have them sign a time card that says I was offered and I've taken all of my rest and meal periods. You have to, all of those things have to be check. And then you still want to remind them
You can.
every week or something, hey, remember you can take your break. We're not stopping you from being able to take your break.
And it could
Here,
be.
will you sign this that says, yeah, I know I can take my break.
So it's not like the 30 minutes where, oh my goodness, you better have them clocked out and clocked in and show that they took it, and there's very tons of rules around that 30-minute period. The breaks, again, as Denise said, it's really that culture. What we always tell a client is asking us, we say, okay, if someone from the DLSC shows up and they say to you, they go to your employees and they say, are you able to take your breaks? What would that employee say, right? If that employee would say, yeah, if we need to go to the refrigerator and hang out for a minute, or we need to go outside and make the call, we're allowed to do all that. That's a culture where even if it's not a strict, set 10 minutes, that's okay. If, however, that person goes to that employee and the employee says, oh, we get to go to the bathroom once or twice a day, but that's really all we're allowed to do. Or I've asked my manager, 10 times to take a break and they tell me no. So why is the employee waiving their 10-minute break? I mean, you need to encourage it, but you don't have to monitor them. It's not like the meal period at all.
But the law is going to favor the employee.
Oh, yeah.
They'll believe
That ever
the
comes up?
employee over you unless you've got documentation or something. I mean, let's just face it. You do business in California, you've got to accept that fact. That's why we don't have employees, nor will we ever.
Just gotta stand there.
Erin, why does she always say that? We're going to hire all independent contractors.
It doesn't
We're
smoke
fine.
break. It smells like that's kind of given, right?
Yes. Yeah, that's a good one. If you have employees that go out and get to take their smoke break, that's going to be their break. Yeah. And they can't do it inside the building, even if it's short. Okay, I love these two. So some more just to kind of open your eyes. Denise and I are passionate. I don't know if that's the right word. We're sticklers for wage and hour stuff because unlike a lot of the employment laws where there's he said, she said, and this and that, wage and hour for the most part is really black and white, right? You're either doing it correctly or you're not doing it correctly. And maybe with the exceptions of the 10-minute breaks, most of it doesn't even matter if your employee wanted it a certain way. So my employee doesn't mind working 8.5 hours a day without me paying them overtime. But all that stuff doesn't really matter in wage and hour. It's really black and white. So here's a couple cases that kind of highlight how little mistakes through lots of employees over many years, because in a lot of wage and hour claims, you can reach back 4 years for the statute of limitations, so it adds up. Anyway, $54 million against Walmart. None of us are Walmart, I understand that. But it was a Fresno plaintiff's attorney. You're all supposed to go, ooh, right? Because that means there's someone locally who's really aggressive about wage and hour stuff. There's quite a few, actually. They weren't paying their truck drivers for non-productive time. So while I'm sitting there in my Walmart truck waiting for the delivery, I'm not getting paid for that time. And the court said, nah, that's no. They can't go anywhere. They're there suffering because of you. So you need to pay them for that time. Sorry, just an interesting case, I thought. $946,000 for charging employees for uniforms. Okay? Company deducted uniform costs from their paycheck. Pop quiz. Do you ever deduct things from the final paycheck other than taxes? No. Exclamation mark, right? Don't mess with that final paycheck. Don't mess with paychecks, actually. But, so this company was charging for the uniform, and if you didn't return it, we just took it off your paycheck, right? And so they were hit with $946,000 in fines because every time they didn't pay them their full wages, that's a penalty, right? Every pay period. And then there's waiting time penalties. And then there's interest. And so it got up to $946,000. A local Clovis company, itty bitty kind of mom and pop, they, in good intentions, were deducting $1 a paycheck for laundering the uniforms, but they didn't have a policy written. They didn't notify the employees properly, and they were hit with $45,000. They settled. But just, it does happen to the small guys just as it does happen to the big guys. And that probably hurt them as much as the $54 million hurt Walmart, right? So again, just to emphasize that you need to be very careful about following all the laws, and definitely wage and hour laws. Okay, so last but not least, we're going to talk about local agency trends. And this is just kind of, you can do a little asterisk. This is just from Core HR experience, not, there's been no articles published on it or whatever. However, we are seeing, and in the legal community, we are seeing these state agency audits like through the roof. And that's across the board. So it's the EDD, it's the DLSE. Who am I missing? Those two are the big ones. And they, look very hard and very carefully at things like time cards, pay stubs, handbooks. They can just basically open their arms up, grab all your information, then they get to go back to their offices and they're combing through it. And if they find something, there's going to be, potential fines and et cetera levied against your business. So we're seeing an uptake in this. So just something to be on the lookout for, and cooperate with them, but know that better to get your ducks in a row now before you see that auditor on your doorstep, right? So I don't see this stopping in 2017. I see it probably as something that's going to increase. So just be aware of that. Yeah, Uber. The independent contractor thing is huge, especially in certain industries. We have a client who's going through an EDD based on their independent contractors, and it's really, really nasty. So if you use independent contractors, and you don't have to raise your hands, just make sure they're truly an independent contractor and not just an employee that you don't want to pay workers' comp and unemployment insurance on. Because EDD is coming after, they want the money, right? They want their payroll taxes. All right. Again, asterisk, this is just kind of Core HR's, after, we read through legal blogs and whatnot all the time, kind of what we think is going to come up in 2017, at least in California. I'm not even going to try to predict the federal level, but in California, some things we are seeing some chat about is this idea of predictive work scheduling. Anyone heard of that? So it's really for those industries, retail, restaurants is a big one, where and there's some like San Francisco, there's already some municipalities that have passed predictive work schedule laws, and it's basically saying that you need to let your employee know that they're always going to work the lunch shift from 12 to 5. And you have to give them a predictive schedule rather than, okay, on every Friday, go check the board and we'll see what we've scheduled you for. Sometimes you're opening, sometimes you're closing. So look for that if you're in that type of industry where people don't work necessarily an 8 to 5 or a regular schedule. Look for that coming. So we've seen just in the last 8 to 10 months, new additions to the protected categories as far as the equal pay statute, gender, race. So my own feeling is that's probably going to continue. Doesn't really make a huge impact because if you're not discriminating against people based on their protected classes under the FEHA, then it's not going to really impact you. But just be aware that it's probably going to continue to grow. Prohibiting even asking or requiring applicants to provide a salary history. I think this one is likely to come about in 2017 or 2018. So we talked about that idea of when you ask prior history and then you make a determination. It's really a negotiating tool, but anyway, that can be problematic. So some legislature or lawmakers are putting forth bills that would prohibit you from even asking about salary history. And it's possible that it would happen. Okay. And then last but not least, we just think this trend of enforcement by these state agencies is going to increase and increase and increase. And in fact, we have been told by a few of their auditors that they are under a directive to really start targeting certain industries and to take on a more enforcement role rather than just kind of a overview, an oversight. So we see that really continuing in the new year. Okay. Questions? Yeah. Sorry. Don't be depressed. You still have a lot. Yeah. I'm always the half full. Yeah. That's why we're the yin and the yang.
I'm happy if it's half full.
Yes.
On 1099, I don't know if this is
Yeah.
do you have to have another job?
So you're talking about independent contractors, right?
Exactly, independent Can anybody be independent contractor, or they have to have another job and be 1099? I always get confused on that.
So there's a lot of different factors that make someone either more likely to be an independent contractor or more likely to be an employee who's misclassified. You don't have to have another job necessarily. So if I am providing some service to you, if I'm completely dependent upon you for my financial well-being, that's going to smell more like an employee. So it's always a good factor if you're trying to say someone's an independent contractor. Like Denise and I, we work for lots of different companies. We're not, 100% dependent on Delray Tires, right? We're clearly an independent contractor. So it's not a requirement, but it doesn't smell good if they're only working for you. Sorry, it might be bad news. Also, if they look like an employee, they walk like an employee, they talk like an employee, they're sitting right next to Bob who's doing the same thing.
They're giving them a handbook,
You're
giving them a computer, they have an office, all of those things.
Yeah. Then they need to be an employee, right? They
They're
are
looking at
an
your
employee.
1099s that you're filing.
Yeah.
They're
Yeah.
I mean,
That's how two of our clients have been popped for an audit, and it's because they're looking at the 1099s. And if you have an unusual amount,
are you paying them quite a bit?
then that's a red flag. And so they're going to pull that out, and you could potentially be audited. So
Based on quantity of 1099s or the dollar value of what you guys want.
it could be either.
Yeah.
Yeah.
Yeah, we had a situation where, I do 2 companies, but one of my companies is a video production company, and we hire talent all the time, either a voiceover or, an actor or whatnot. And one of our talents, so we just paid a one-time fee for her voice, basically, reported her income from us for unemployment. So then when we said, well, she's not an employee, she's a contractor, then it caused all kinds of things, including an EDD audit coming back and saying, okay, we show that you declined. So it was a mess. But even on our workers' comp audits, they've gotten stricter about coming back to say, prove that you have invoices for these people and what.
Yeah, they want your money too.
Oh, yeah.
So the assumption is that they're an employee.
Yeah. You're in
That's where you
compliance.
start.
Yeah.
And then you have to prove that they're not.
Yeah.
And something like a voiceover, I mean, they have a specialized
one-time
talent.
thing, yeah.
But
And if you have someone who's an independent contractor doing the same job as an employee, then you're screwed. That person should be an employee as well.
or I like it when people try to take an employee and maybe their schedules change or something and the employee, wants to be more independent. So they're like, oh, Michelle, we want to take them from being an employee to an independent contractor. No, like that. I mean, those kind of things, there's huge red flags.
Yeah.
So, yeah. Okay. Any other questions?
Do you see any development in 2017 about trade secrets, customer lists, protecting the employer, inquiring employer or employee that takes those things?
Mm-hmm. I don't see anything changing. I haven't seen any new case law. It's fairly well established. If you have something that's truly proprietary, the best thing to do from an employer standpoint is to have that proprietary information agreement and confidentiality agreement as a separate agreement outside of the handbook and whatnot. Have them sign it, and the more specific you can be about identifying what is truly proprietary and is truly confidential, the more likely that agreement is going to be enforced, and the more likely you can have recourse against an employee that goes out. Customer lists are a good one. It's things that they can't find out on their own. It's only because they've been with you.
I was referring though more to a employer that hires.
Oh, so you're hiring someone who's signed the proprietary information agreement.
That employee is now calling on customers
Can you,
of their former employer.
in the offer letter, usually you can put something in there if you're bound by something. Does that help the employer? when
You
they
can- there's-
sign the offer. If you don't know, because if that's the problem, is you don't know, right? That would have been a previous client of a former employer. Is that what you're worried about? And then all of a sudden the former employer is coming to you saying, "What the heck are you doing?" So if you sign,
There's certain protections you as the employer can put into place. You can, like in that offer letter and other documents, you can try to get that person to explain to you exactly what that new employee, exactly what they're getting from they're prohibited from taking from their old employer versus what they're not. But other than that, there's not a whole lot you can do.
This being a right to work state, can
I thought non-competes were legal.
No, so this is different.
It
So
is-
this
but
isn't.
You're right,
yeah.
non-competes are
You can't
lawful
have a
in
non-compete, but
California.
this is a proprietary
Is that
agreement.
The customer list and everything would be the same? That's what you have to
Yes.
define.
That's what you have to
very
define.
carefully, yeah.
You can't just say everything and anything in this building.
Right.
You really have to be specific.
But yeah. Those are
Paul
hard.
said something about a right to work state. Where we are
Yes,
right
it is
to
a
work.
right to work state, Paul.
Right.
well, because if I'm gonna go work for him, he's hired me, and I'm in sales. I mean,
Yeah, but
I
if you're
want,
so the customer list is
That
tricky.
customer
Let's say
list
that
is-
you know the right guy at Core HR to go after, right? You know their personal email address, you know their personal cell phone number, and you know that kind of information only because of working at your previous employer, and that information has been protected because you've signed an agreement. That is different than me just saying, "Oh, I know, this business may or may not be interested in HR services. I'm just going to go approach them." Anything that's public information, their general number, that sort of thing is not going to be protected.
so if I as the salesperson, and that's really where that customer
customer or client relationship that's kind of born. If I develop it, had nothing to do with my company, my employer.
It always has something to do, because you're selling a product
Right.
that this company, I mean, there are certain industries where you're selling a lot of the same stuff. It'd probably be harder to say that's proprietary information, but
It's hard.
yeah. It's hard, isn't it? But the employee has a lot of protections, but there are some certain things that employers kind of
Yeah.
require that they don't use.
And, yeah.
We have a lot of our customers that we have to sign confidentiality agreements about their processing
Mhm.
lines and stuff. Can we extend that to our employees when we hire them?
Yes. Yes.
Yeah, like if you know that the secret to Coca-Cola and you're going in to that area, you can definitely, that company would probably have your employee sign.
Yeah.
that
Even a lot of their
confidentiality.
processing lines
Yeah.
are proprietary.
Yeah.
Yeah, no, that's fine.
Are you very familiar with FSAs?
No.
We don't usually touch benefits.
Yeah. So
Yeah, the flexible spending.
Yeah.
yeah, I know there's been a lot of changes, but no, that's not something. We don't really touch benefits.
Affordable Care Act, we don't touch.
They're all itty bitty, not itty bitty, but they're under
But
50.
still, they're still a part of the ACA that
Yeah.
applies to everybody. Yeah.
Which is, it's like a little change.
We'll see.
Who knows?
We'll see.
If there's no more questions on the back of the PowerPoint, there's our contact information and on our flyer. And for IFB folks, we are offering to do a free risk assessment. And if you want to know if that's painful or not, you can ask Erin. Because she's gone through it. And it's just a free meeting. We meet with you. We kind of go through the life cycle of employment, which is this little doodad here. And we get kind of a general idea of where you stand in your HR practices. We let you know if we think there's any risks. And of course, we tell you how we would like to fix those risks, but it's no obligation. And I guarantee you will learn something during our meeting. And it's complimentary, takes maybe hour-ish, depending on how many questions you have. So if you want to contact us to get that set up, give us a call. Again, our information is on the flyer and in the PowerPoint. And right there. And thank you. And again, thank you for your time and your great, great questions. We really appreciate your attention and having us here tonight. Turn it back over to you.
Thank you both. You said something about alcohol in the workplace. We want to thank you, Fresno State Line, as a welcome, and appreciate everything. Let's give them a big hand. And there's plenty of food, I'm sure, still out there, so please grab a sandwich and stick around for a while if you'd like. So thank you for being here.